Hey, good afternoon. This is Nick Merker, and this is another privacy chat. As you know, this is a 10 to 20 minute kind of overview of trending privacy topics that may be of interest in the current kind of situation that the world is in. And I am Nick Merker. I'm the chair of ICE Miller's Data Security and Privacy Practice. You can contact me at nick@icemiller.com or as at @nmerker on any of the social media platforms on the right, including Twitch, Instagram, YouTube, Twitter, or Facebook. Today, we're going to be talking about bankruptcy, and in particular, how privacy gets involved in bankruptcy situations. And it's a really interesting topic because there's something directly in the bankruptcy code for a privacy situation. So let's go through a hypothetical real quick. You are a company that collects personal information for a million people. You're consumer facing. Let's say you're a retail company and you have a rewards program. You have a million people in your rewards program. You have 2 million people that have purchased things from your store. And so you have this massive database of rewards information and a massive database of just purchase information. Well, what happens when your company goes bankrupt because no one is purchasing anything from your store anymore and you have no revenue? Um, in a bankruptcy proceeding, the debtor may say, these databases of personal information have great value. Not only do we have the purchase information, but we have the rewards information tied to that purchase information. And the rewards information includes marketing activities. It includes something that if I sold this to a personal information aggregate company, it would be very valuable to them. It would help people make decisions on a marketing basis based off this information. So I want to sell this data in a bankruptcy proceeding because it has some value. In a bankruptcy situation, what would happen here is uh, you would look at the privacy policy of the debtor, of the entity that's going bankrupt. What does their privacy policy say? And if the privacy policy says, yeah, we can sell your information for any reason at any time, it's just very, very open, then, the decision is kind of done. The personal information in these databases becomes an asset and it is sold. However, if unless there's some law preventing them from doing so, like the Children's Online Privacy and Protection Act, or let's just say that the privacy statement, although it says we can sell your data, the privacy statement is in non-compliance with some United States law, and so then what I'm about to talk about would come into play. In other situations, let's say that the privacy policy says something like, "We will never sell your personal information." But in the bankruptcy world, the debtor says, "Hey, I have this asset. I have these databases that are worth a lot of money. I want to sell them. Can I do so?" And what happens then is folks look at a privacy ombudsman will come in, and this is 11 U.S. Code 332. This is right in the bankruptcy code, and it says, hey, if there is a issue associated with privacy on is it okay for them to sell this information? If that is in question, then there can be an appointment of a privacy ombudsman. And a privacy ombudsman is a neutral party that would act in a hearing about personal information to assess whether a sale should occur. And the privacy ombudsman, they're supposed to be neutral. And so they will look at the privacy policy. They'll look at the potential losses or gains of privacy to consumers if a sale or lease is approved by the court. They'll look at the potential costs or benefits to consumers if such a sale or lease is approved by the court, and they'll look at the potential alternatives that would mitigate privacy losses or potential costs to consumers. But the real kind of critical item, the thing that they look at first, is a privacy policy. Um, and the privacy policy at issue is there's been a lot of questions on which privacy policy is applicable. So if let's say I know I'm about to go bankrupt, I'm this retailer in the example that I just described. I know I'm 10 days from bankrupt, and I immediately change my privacy policy to say, hey, I can sell your information at any time for any reason. Don't worry about it. I'm going to sell your stuff, especially in bankruptcy. I add in all bold. Um, and so we go into this bankruptcy situation, and the debtor wants to sell this data to recoup some losses. And the court would say, well, okay, you just changed your privacy policy right before bankruptcy was at issue. Is that privacy policy the only thing to look at? And the answer to that should be a very hard no. And we know that because of the Facebook versus FTC settlement and all the way back in 2011. If you remember there, what happened is Facebook had updated their privacy statement to include some, as the FTC thought, materially negative things or new ways that information would be used in a non private way for the benefit of Facebook and not the consumer. They changed their privacy statement, but they didn't go back and ask whether consumers were okay with these changes. And so the FTC said, you have to do that. That was their settlement in 2011. Essentially, if I'm going to change my privacy statement in a way that materially impacts a individual, then I need to get their consent or inform them of this change before I start processing that personal data in a new way. Let's think about it this way. If I am, let's say, a social media or a retailer, let's make my retailer, for example, and I go into a store and I say, yes, I would like to sign up for your rewards program, and the retailer hands me a privacy statement immediately there at the counter. I read my privacy statement to go, okay, I consent to this. This is fine. And then I walk out the door and the retailer changes that privacy statement, but they don't tell me, then I'm never in a position to know that my information is being used in a way that conforms to the new privacy statement and not what I agreed to. So, from a practical standpoint, it makes complete sense. And so, a privacy ombudsman will look at more than one privacy statement. They'll look at the privacy statement that was used at the point of collection, if available, and they'll look at future privacy statements that may have changed. Um, However, if a individual is consents to some new practice or they're informed of the new privacy statement, then maybe the only privacy statement that an ombudsman would look at is a privacy policy. So it's just important to note that if you're a company that is sitting there thinking, are we prepared for a bankruptcy situation if one needs to arise? Your privacy policy is critical in that analysis. It's right in the code. That's why I put it here, and it's critical to be analyzed. And so let's look at one of these and how it actually worked in play. And we're going to look at the Crumbs Bake Shop case. And I don't have the citation here. Let me actually give it to you. This is I should have put in the slides. But this Crumbs Bake case is from 2014, is where I pulled this filing from. And it is from the bankruptcy court in the District of New Jersey. And the citation that I'll just tell you that you could write down if you want to look this up, it's 14 24287 in the New Jersey District Court, bankruptcy court. Um, and here, what happened is that Crumbs Bake Shop had a bunch of information, and they were going through a bankruptcy situation. Then they were forced to cease operations due to severe liquidity problems. And the bankruptcy court entered an order approving that the bidding procedures, and they scheduled an auction and a hearing to provide the assets to the highest and best offer in that auction according to those bid procedures. And in the access purchase agreement, as part of that bidding, the purchaser would be purchasing all of the debtor's books and records, as well as tangible personal property and intangible assets, including their intellectual property. And customer lists were being sold through that sale. So the Crumbs Bake Shop has a privacy statement, this is pulled directly from this motion. And this is from the U.S. trustee that filed this motion, which their relief sought in this motion was for the appointment of a privacy ombudsman pursuant to 11 USC 363 B1 and 332. So the part of the code that we just looked at. And they said, as part of their motion, hey, the privacy statement for Crumbs Bake Shop says as follows. Crumbs Bake Shop, and I'm just going to read this verbatim. Crumbs Bake Shop is highly sensitive to the privacy interests of consumers and believes that the protection of those interests is one of its most significant responsibilities. It's a pretty kind of flowery statement, but a very powerful flowery statement. And Crumbs Bake Shop has adopted this privacy policy applicable to information about consumers that it acquires in the course of its business. And Section 3 of that privacy policy says we'll provide individually identifiable information about consumers to third parties only if we are compelled to do so by order of a duly empowered governmental authority. We have the express permission of the consumer or it's necessary to process transactions or provide our services. So in a bankruptcy sale, this privacy statement does not say that the information can be provided to third parties. It actually says quite the opposite, that they will not do so unless they're compelled to do so by a court, they have the consumer's consent, or it's necessary to process transactions. So the U.S. trustee wanted a privacy ombudsman here because the privacy policy only allows a transfer in the items that I just said. And if the sale of the customer list to a third party does not fall within one of these carved out exceptions, then the sale is prohibited. And so we need a privacy ombudsman to come in and assess whether this is appropriate to do, because to read that policy differently, as they say, would render the debtor's privacy policy meaningless, leading consumers to believe their personal information is protected when, in fact, it is not. So they wanted this ombudsman to be appointed. Interestingly, the court granted this motion for the U.S. trustee to appoint a privacy ombudsman. And what I thought was interesting is that then the U.S. trustee just gets to pick their ombudsman. And they picked an attorney with a CIPP out of New Jersey to be the ombudsman in this case, which I thought was really interesting, that they can just pick the ombudsman. But the ombudsman had to file a statement saying that he was a true neutral. He had no economic ties to Crumb's Bake Shop. I want to focus in on one thing here, though. Let's go back to the law. So they look at the debtor's privacy policy, and they look at these other three factors. Well, look at the policy number 2 in the motion from the trustee here. They say that if the debtors have the express permission of the consumer. Well, if you go to most company websites, and if a privacy policy says we will disclose your information to third parties upon your consent, in terms and conditions, sometimes we include language that talks about you consent to us disclosing your information in accordance with our privacy policy, or maybe it has language like you consent to us disclosing your information in the event of a sale or transaction involving the assets of the company. And if you looked at that in light of this privacy statement, I would argue that there would be consent there, that you consented in the terms of condition when you purchase something online at Crumb's Bake Shop. I didn't really dive into the facts here, but because it has this consent catch-all here, you could snake your way into being an acceptable sale because of consent from a terms of use. So what happens when a sale of information occurs that is outside of the bounds of the privacy statement? Remember, let's go back to the language directly from the statute. And what happens is the privacy ombudsman appears in this hearing, and they provide the court information to assist the court in its consideration of the facts. And that may include the privacy policy, losses or gains to privacy, and these other factors. It doesn't mean that the court immediately says no if a sale is at odds with a privacy statement. What can occur is the court can decide that a sale is okay, even if a privacy statement says otherwise. And we have an example from this in a Toy Smart bankruptcy from the year 2000. And the Toy Smart bankruptcy created the template for the sale of PII in situations where the privacy statement says no. So Toy Smart was a company that sold children's toys online. And as you know, from the year 2000, this was kind of the dot-com crash. And Toy Smart at the time was collecting personal information like names, billing information, what products were purchased, addresses, and the like. And the privacy policy in Toy Smart said it would never share information with third parties. And so in bankruptcy, Toy Smart wanted to sell its assets to make some money. And the FTC brought an action for injunctive relief saying that no, you cannot do this. Toy Smart said they will never sell information. And so to do so would be render that privacy statement meaningless, similar to the allegations from the U.S. trustee in this case. And the court, however, came a what's called the Toy Smart framework. So the Toy Smart framework, you can have a sale of customer information in a bankruptcy proceeding in the following situations. 1, the customer information was sold as part of a package with the debtor's assets. 2, the buyer was a so-called qualified buyer, or meaning they're in the same line of business as the debtor. 3, the buyer agreed to comply with Toy Smart's privacy policy with respect to purchased information. And 4, the buyer notifies the affected customers and obtains their affirmative consent before using their information for any new uses. So this, to me, is a little interesting. This means that in, let's say, the Crumbs Bake Shop cake, that Nick Merker's bake shop can purchase their purchase their customer list, provided that Nick Merker is in the same. He's a bake shop, as I just mentioned, and it's part of a package of the rest of Crumb's Bake Shop's assets. And I agree to comply with Crumb's Bake Shop's privacy statement when assessing this information. And if I'm going to use the information in a new way, then I get their consent. Doesn't this still fly in the face of this privacy statement? Because the disclosure to me should never have even happened. Nick's Bake Shop should not get this data. Just because I bought all of Nick's Bake Shop's pots and pans in addition to their customer list means I can get at this data. That seems to go against this privacy statement. So the Toy Smart framework is an interesting framework. If a major retailer, also, what is a qualified buyer is would be in hot debate. If a major retailer that sells electronic products goes under, and would a qualified buyer be a major retailer that sells household products, or would a qualified buyer be a massive conglomerate retailer? I don't know the answer to that, and that's something that would be assessed in this privacy court. So I just thought this area was really interesting for a couple reasons. The first reason is this privacy ombudsman is directly within the realm of the bankruptcy code, and a privacy ombudsman will be appointed by motion, but it will be appointed by the court to provide kind of a neutral view on whether the sale of personal information should occur. And it's just a really interesting area, and that if you're a qualified attorney or individual that can provide this kind of neutral party, you can be appointed, as we saw in this Crumbs Bake Shop case. So with that, that was a privacy chat today on bankruptcy and privacy ombudsmans in particular. And thank you for tuning in. Again, I'm Nick Merker. I'm Nick at icemiller.com or at nmerker on any of the social media platforms on the right there, including Facebook, Twitter, YouTube, Instagram, or Twitch. And thank you for tuning in. Have a great day.